telling me you live a wild life. Say your lies don't hurt nobody. Only meant to know yourself. All the white lies only get bigger.
Sago, it is March 19th, 2018. I want to welcome you to Let's Talk Native on the LTN Radio Network. This program breaks all the rules for Native radio. No buffalo speeches, no mystic healing, no special Indian prayers. We tackle the real issues facing Native people with a look back at our glorious and our grave history, a tough look at where we're at now, and a look forward to our ongoing battles for sovereignty and autonomy. Let's Talk Native is produced in association with Iroquois Promotions on the LTN Radio Network, streaming live from the Kannadiga territory of the Seneca Nation and simulcast and rebroadcast on the Gwe, CKWE in Kannadiga. You can find us streaming our audio at www.ltnradionet.com. And, of course, we are live streaming here on Facebook Live, so you can check out video of the show and you can see the mad expression I'm going to have through most of the show today. I am John Kane. I am the show's host and producer. And, again, you know, I am happy to do this show, but some days when I come in here to do this show, I am not happy, and this is one of those days. You know, we fight the state and the federal government and, you know, and of course, corporations on a daily basis. And many people look at our battles as if they're like in the rearview mirror, like they all happened, and we just have to take our lumps and live with the outcomes and that kind of stuff. That's what we're told all day. We're told to get over it. So in the meantime, we've got two rivers through two territories that are contaminated by the energy industry. The Kannadiga Creek, which is still trying to assess what they're going to do about the radioactive contamination from West Valley Nuclear Storage and Processing Facility, 30 miles upstream. And, of course, now we're facing another challenge with the hydrofrackers wanting to dump their contaminated water in a water treatment facility that can't treat hydrofracked water at the headwaters of the Allegheny River, which flow through the Allegheny territory of the Seneca Nation as well. So we have all that. And you know what? In the wake of Standing Rock and everything else, it's real easy for people to step up and say, well, I'm a water protector, and I'm going to fight for water. Water is life. But, and while that's true, I think it's really important that people realize that it's not enough just to fight for something like water. We have to fight for our very existence on a daily basis, and that very existence includes how we sustain ourselves, not just in terms of the water that we drink and the air that we breathe and the food that we grow, but in the world that we live in a monetized system, as much as I wish we didn't. And we, as Native people, have learned how to create an economy out of our regulatory advantages. And those regulatory advantages don't stop, but they include our tax advantages. You know, we have built a pretty vibrant economy out of our sales of gasoline and tobacco products. But we've had to fight the state and the federal government every step along the way. Obviously, people associate Native economies with gaming as well. That's another battle that we're faced with all the time. Right now, the Seneca Nation is in the throes of a battle with New York State trying to squeeze them for revenue that they've done nothing to earn. Revenue that they have no legal basis to claim. And that's New York State. That's the beloved Andrew Cuomo, who sits in the governor's mansion and who still enjoys like a 52% approval rating or something like that. And in all likelihood, it doesn't look like the Republicans or anybody else is going to put up a challenge. So Andrew Cuomo is what he is. But do people realize what he is? You know, when Native people are battling the state governments or federal governments, the assumption that too many people make is that the Republicans are bad and the Democrats are good. Well, I got to tell you, we have every bit the fight with a Democrat in office, whether it's Barack Obama pushing through the Dakota Access Pipeline. Yeah, I said it. He's the one who pushed the Dakota Access Pipeline through, not Donald Trump. Donald Trump just opened up the freaking valve. But make no mistake about it, it was Barack Obama's baby. And you know what? Hillary Clinton was right behind it as well. And so was Heidi Heitkamp and Claire McCaskill and a whole bunch of other prominent Democrats who want to pretend that somehow they have environment or they have native concerns, any place on their agenda. They don't. And when it comes to New York State, we've been in a constant battle with Andrew Cuomo. Even fighting him has been worse than fighting his dad. And most of our battles with New York State, at least in modern history, began with Mario Cuomo. So what am I pissed off about? Well, let me tell you what I'm pissed off about. A couple of days ago, a ruling came down in the New York State Division of Tax Appeals against my buddy Eric White. Eric was was apparently committing this heinous crime of commissioning commerce, native to native commerce, with a native product, native driver, native company, native distributor's license, and New York State says, "Oh hell no." In fact, this case goes back a number of years, and not only had they brought a penalty and a fine, a charge against Eric, but even his driver, who was just a young guy, Sean Snyder. They wanted to fine these guys $1.3 million. They're carrying about $160,000 worth of cigarettes. Native branded cigarettes that was going from a Seneca Nation licensed wholesaler on the Cattaraugus territory of Seneca Nation to Gunyonge. A perfectly legitimate transaction, one where bill of lading and invoicing, all of the stuff was had accompanied the driver. Sean had all that stuff with him. So they seized $160,000 worth of tobacco products. They don't charge Sean with anything. They let him go. Actually, they even let the truck go, I guess. Kept all the cigarettes, and then assessed a fine of $1.3 million for anybody involved. Sean, Eric, the company, anything. So Sean fought this thing, as did Eric. And in fact, I testified in that hearing. And the judge in that hearing threw Sean's fine out. Just threw it out. Dismissed it. Threw it out. Nothing. No fine, nothing. But they kept pressing on Eric. And just a couple of days ago, they made a ruling denying Eric's appeal to have this fine either adjusted or just thrown out. Now, here's the thing. This was specifically a native product being sold by a Seneca licensed wholesaler to another native territory. Now, this product is not available for sale in the state. This wasn't a truckload of Marlboros or Camels or Newports. It was a specific native brand that's only available in native territories. And it was sold from a native wholesaler to a native retailer, one territory to another. Now, when New York State went after these guys on this, they cited every New York State law that governs or that regulates their control of tobacco. And in every instance, they kept saying, well, any cigarettes in New York State, any cigarettes sold in New York State, any cigarettes being transported in New York State, and all. They cited all these laws, none of which should apply to native trade. And in fact, we'll go back a few years. I personally got two state senators, Tim Kennedy, a Democrat, and George Maziarz, a Republican, to write a letter to the tax commissioner, Tom Maddox, the Cuomo administration, not just asking, but essentially demanding that the tax commissioner put in writing what is the state's policy on native to native trade. I mean, they took a clear position that the state did not have the authority to regulate or interfere with native to native trade. That's a position that two state senators from different parties took. And in taking that position, they were asking clearly for Tom Maddox, the commissioner of New York State Department of Taxation and Finance, to put it in writing what the state's policy was. He refused. He refused it for 1 year, for 2 years. And in fact, George Maziarz wrote several letters and made several phone calls after that. And each time, the state refused to answer what was their position. Now, to be clear, the state can't pass laws or have policies and then hide them. They can't say, I have this policy, but I'm not going to tell you what it is. And they really can't do that and then turn around and say, oh, Eric White was operating in clear violation of state law. Well, how the hell was it a clear violation if you don't have the guts to even stand up and say what your position is? And by the way, that position is a stark violation of the UN Declaration on the Rights of Indigenous Peoples. International law clearly states that we have the right to conduct commerce and to utilize our territories for that commerce. Now, the fact that the state is saying, oh, yeah, they're violating state law, we weren't selling cigarettes in New York State. Seneca Nation territory is not New York State. Now, how do I know that? Because New York State has no claim to the territory. And in fact, if you look at even language that was well crafted by the federal government back as far as 1794, the United States will never claim your territory. The United States recognizes that your land is yours, and the United States will never claim the same, nor interfere with the free use and enjoyment of that territory. That's the federal government saying that. The federal government wasn't saying, we will never claim your territory, but New York State will. No, that's not the way it works. And in fact, for almost a full century, and in fact, take it back, for more than a century after that, it was clear that the United States recognized the Seneca territory, and not just Seneca territory, all Six Nations territories, were not part of the United States. And so did New York State. New York State was clear that not only did their legislature not represent Native people, but they also had no claim to our territories. Part of my testimony in Sean John's case, had to do with the argument that the state was trying to make that Kannadiga wasn't a native territory. They were saying it's not a reservation. And I testified as an expert witness on the case. As you're right, it's not a reservation. None of our territories are reservations in the sense of land set aside by the federal government for our use and enjoyment. To the extent that we've ever used that word, it was a word that when we said it, we meant lands that we reserved for ourselves, lands that we refused to sell. Kannadiga is a little bit of a different situation because that was land that was taken back, physically taken back by Mohawks. But there is no question that Kannadiga is a native community. And you know when that was established? Not just when Andrew Cuomo's dad was the governor. No, before that. Before he was the governor. He was part of the state's negotiating team when the Mohawks took land in Moss Lake originally, and then basically asked the Mohawks if they'd be willing to relocate to this territory up near Plattsburgh. And that is that is now Kannadiga. This was something that started in the 70s. And again, Mario Cuomo was a lieutenant governor or state attorney general. I don't remember what he was, but whatever he was, he was the guy who negotiated this on behalf of Hugh Carey. So it was clearly established by Andy's dad that this was a native territory. And the fact that we are still having these battles with New York State over our right to conduct commerce. And, and here's the thing. They cite all of these state laws that regulate the state tobacco industry. We are not the state tobacco industry. We are native territories that are outside New York State. And there's no question about that. And in fact, if the state really felt they had the right to really regulate our commerce, then they would come right out and say it. They should come right out and say, look, we don't respect your right to have native to native commerce. Your commerce is our commerce, and that's final. And we don't recognize the UN Declaration on the Rights of Indigenous Peoples. We don't care if it's international law. We're New York State. We're not bound by international law. Then come right out and say it. But you know what? You're gutless, Cuomo. You're gutless, and so is your tax department, and so are these attorneys who are fighting this stuff. Look, I was thrilled to death that they threw the case out on Sean Snyder. But the fact that they're still going after Eric White on this, and again, if you're listening to the show and you're not pissed off, then maybe you're not paying attention. Because you can stand by the river's edge all you want and claim to be a water protector, but if you're not prepared to fight for our sovereignty, then I don't know what the hell you're doing. Because we have to draw a line in the sand on this up. You know what? That New York State Thruway flows through this territory. Commerce unimpeded every single day, every hour of every day. They have railroad tracks going through there, commerce unimpeded. They're carrying toxic materials, bomb trains, and everything else on those railroad tracks. We don't do anything to interfere with their commerce, and yet we can't take a truckload of a native product from one territory to another without having this happen? And look, this doesn't matter that it was going to Ganyange. This could be a truckload going from Cattaraugus to Allegheny, and it wouldn't make any difference. In fact, if you recall, a number of years ago, they seized a truck that was heading to Allegheny from Cattaraugus, then released it a little while later. And, you know, the thing is, my testimony in Sean's case was considered in this case. It's, you know, I'm perusing this case, this 54-page ruling or whatever else. And they even cite the George Maziarz and Kennedy letter. And what they said is, well, that was those letters were written during a period of time that the state was practicing a policy of forbearance. Well, you know what? If that was the case, then why didn't they announce when that forbearance policy ended? Without just seizing a load of tobacco. Why didn't they say, we no longer are forbearing our authority against Native people? In fact, we're asserting all of our state authority against Native to Native trade. We aren't recognizing. I mean, by this standard, the state can come into any Native territory and start ripping product off the shelves. Why? Because New York State says if it's in New York State and it doesn't have a stamp on it, it's illegal. And they are claiming that our territories are New York State. They do it all the time. They hesitate when they say it, and they try to be sneaky about how they say it, but that's their position. And the fact that they are willing to interfere with Native to Native commerce, our ability to even truck something from one territory to another, is illegal. Now, they can say that it's their legal right, but they're wrong. And even if they have New York State law that says they can do that, that New York State law does not apply to us. Not that New York State law. Look, they want to pull us over and give us a ticket for a bad tail lamp. Yes, I just had that happen to me the other day, or today. You want to do that? That's one thing. But if you're going to say, no, we have the right to stop you from conducting Native to Native commerce. No, you don't. International law says you don't. Our own sovereignty says you don't. The question is, are our people going to say you don't? And what are we finally going to do about it? Look, I am all for fighting for clean water and clean air. But I am not going to sit back and let New York State continue to screw us out of our right to have an economy, whether it's them trying to screw us out of revenue from gaming. And I hope to hell the Seneca Nation does not cave on this thing. I don't care if they're afraid of New York State's power to take their liquor license away so they can't serve alcohol. Then you know what? Do it anyway. The hell with New York State. Akwesasne has their own laws on the books. I don't know. I don't know if they're selling booze under a New York State liquor license. But you know what? Maybe the Seneca Nation shouldn't be doing it either. They want to serve alcohol in the casino. They should be doing it under their own sovereignty, not under New York State. They are not conducting gaming under New York State, and we are not conducting our tobacco or our fuel businesses under New York State. We have to be clear in what our opposition is. Now, of course, they cite all of these state laws, but the other thing they do is they cite, invariably, they're going to cite the Attea case. Now, I'm going to give just a brief explanation on what the Attea case was. So when Andrew Cuomo's dad was the governor, he tried to stop New York State wholesalers. When we were first doing the tobacco business, We didn't manufacture our own products. We bought from New York State wholesalers. We convinced the New York State wholesalers that our sovereignty was as such that they didn't need to stamp the products that came to our territories. And you know what? New York State had to scratch their head. They didn't know. So for quite some time, New York State was trying to stop their wholesalers from selling us product without a New York State stamp on it. And they had a difficult time doing that for a long time. But Mario Cuomo tried to pass a law that would force New York State wholesalers to stamp product, and then create this stupid policy that, we could do either a quota system or a coupon system so we can make sure that New York State isn't inadvertently taxing cigarette products that we consume ourselves as Native people. Of course, that was a debacle also, and it never took into account the fact that they don't actually have a right to tax product that is consumed on our territory, whether you're Native or non-Native. In fact, they don't have the right to tax product that leaves our territory and enters New York State unless the purchaser is carrying more than 2 cartons. Under New York State law, not our sovereignty, nothing like that. Under New York State law, anybody can have up to 2 cartons of cigarettes without a New York State stamp on it on their possession in New York State. So they can buy it in Pennsylvania or New Jersey or Canada or Venezuela or any native territory. And if they're pulled over by a police officer, and if it's under 2 cartons, you know what that is? It's tax exempt. And that's under New York State law. So any of this myth that New York State has the right to tax our sales, no, you don't. The only thing New York State has the right to do is tax the use and consumption of tobacco in New York State. And it's called a use tax. But if you look at that form, CG15, look it up, New York State, CG15, it says 2 cartons or less are tax exempt. That's not our law. That's New York State law. Now, I'm not suggesting that if somebody buys 5 cartons of cigarettes that we shouldn't sell them 5 cartons of cigarettes. That's New York State's problem. That's their collection problem. That's not ours. We're not taxing agents. But here's what Attea did. When Mario Cuomo tried to force them into stamping the product that they sold to our territories, they said, wait a second, we have a federal Indian trader's license issued by the Interior Department. And our federal license to conduct commerce with Native people supersedes state law. That's how they challenged Mario Cuomo's law. And at first they lost, and then they appealed it, and they won. Went all the way to the Supreme Court, and the Supreme Court said, we have 2 other cases that have nothing to do with New York and have nothing to do with Native people in New York. And in fact, we're going to rule on this case, but we're not going to rule on this case based on any sovereignty of Native territories, any treaty rights. We're only going to rule on this case based on what they call a facial challenge. And that facial challenge is, does a federal Indian trader's license supersede state law? That's what went to the Supreme Court in the Attea case. Nothing more than that. And what the Supreme Court ruled was, we have 2 cases, one called Moe and the other one called Colville, where the federal courts ruled that the states could impose a minimum burden on tribes to collect taxes on cigarettes. And in these 2 cases, those 2 territories, the Moe case and the Colville case, Moe was versus the Confederated Tribe of the Blackfoot, and then the Colville reservation case. Those territories are nothing like our territories here. For one thing, those are trust lands out there, lands that are held by the federal government for the free use and enjoyment of Native people out there. Plus, they're checkerboarded. And if you know what checkerboarded means, that means that those people have already had their lands subverted by speculators, by land purchasers, and the federal government was complicit in it. And so there might be areas of both those territories where you can't tell which houses, one house might be considered on the reservation and the next one wouldn't. So it's like a checkerboard. Some were sold off, white people have them. Some remain part of the native territory. None of the municipal services are being provided by the quote-unquote tribe. So a completely different situation in the Moe and Colville case. But regardless, the Supreme Court said, and the U.S. Attorney argued, that since we have two cases where the courts have ruled that the states can impose a minimum burden on the tribes themselves to collect taxes, then how could a non-native New York State wholesaler supersede state law? If the tribes themselves in the Colville case and the Moe case didn't supersede state law, then how could a non-native wholesaler? That's the reasoning. That's the ruling. So the ruling went against Attea. But in the language, in the very specific language, there's a line written in the opinion on this case that says what the New York State was attempting to do that led to this battle over a New York State wholesaler, which was to pre-collect a tax on a product that was coming onto our territories without state tax and then sold back to New York State residents without that tax. So it was simply a tax avoidance scheme. That's the way the federal government ruled. They said, so what New York State was trying to do in terms of taxing a product that we didn't manufacture, that we simply bought off from a New York State wholesaler and then turned around and sold it without tax. The Supreme Court said that stands on markedly different ground than product that we add value to, either through manufacturing, marketing, distribution, branding, blending, contracting, whatever. If there's a product that we add value to, New York State doesn't have the same kind of right to impose a tax on that. That's what was said in Attea. So if you're going to bring up Attea, you better bring up all of Attea, especially the part of Attea that specifically addresses native-to-native trade, that specifically addresses a native product. Because if you don't, then you're lying. You're cherry-picking bits and pieces of information to basically state something that's not true. And that, my friends, is a lie. So when I see any case that cites Attea, or when I see a newspaper article, or I hear anybody sit there and say, well, New York State was a landmark decision that allowed New York State to tax natives. No, it didn't. No, it wasn't. No, it isn't. It was simply a ruling against Wilhelm Attea, a New York State wholesaler. It wasn't a ruling against us. And in fact, if you look at the language that they cite in Attea about value-added products that we might produce, that wasn't even an original thought for Attea. They pulled that out of Moe and Colville. So the idea that an attorney representing New York State Tax Department would have the gall to cite Attea as some sort of grounds for them to be able to assert their taxes over our native-to-native commerce, it's wrong. Look, it's the bottom of the hour. We're going to take a break, and I'm going to catch my breath. I'll be plenty pissed when I come back, so don't worry about that. But we'll take a break right here. We'll be back in a few minutes.
Sun comes up on another day. wasn't always this way. He used to call me baby 10 times a day. And now the only call I ever get from you is from the bar at 2:30. Feel the light, feel the light. Something going on. Feel the light, and it feels like we got trouble in the wing one. So what's it gonna be? Are we grasping and strong? I still love you, that means anything at all. If you still want me, baby, give me.
So everyone, welcome back. This is John Kane. This is Let's Talk Native. Hey, I want to, before I get back into it, let me thank my sponsors, Ross and Holly John and the RJE family of businesses. And yes, Eric White and ERW Enterprises. I want to thank Eric for supporting the show. But let's be clear. I'm talking about this case not because Eric is a sponsor. I'm talking about this case because we better figure out what we're going to do about it. I also want to thank a couple of individuals who step up from time to time and make sure that that I can keep doing what I do. Guys like Ed Schindler and Cynthia Trice and Neville Spring. Hey, my good friend Sugar Montour was among those people. Again, rest in peace. And look, I want to also thank many others who have helped out. You know, one of the things that, and I mentioned this before, but I played an old show back when we were doing this program on commercial radio at WWKB, and that was commercial radio. And I had, I played a show that had Murray Porter and Sugar Montour on the program, and when I played that show, I left all the commercials in there, and it was interesting to hear all those businesses, mostly here in Cattaraugus, that stepped up and supported the program. And look, I wish you guys were still doing it, but I appreciate the fact that you did it at all. I appreciate the fact that so many of you helped me do this program right from the start. Again, guys like Sugar Montour come to mind. Specifically, he was right there. He was there right from the beginning. But I'm wrapping up my 8th year of doing Let's Talk Native, and I couldn't have done it without all of you. Look, I know I've got I can count on one hand the people who really do support this program today. But if I didn't have all of you who had stepped up in the past, we wouldn't have gotten to today. So again, I thank all of you for joining in the fight and doing your part. And it is a fight. We have stuff that we have to address, folks, and what I'm talking about today is just one of them. Look, I also want to thank Unity Stream and Apache Radio Net for providing our streaming. I also want to thank, again, CKWE for the simulcast and the rebroadcasts of the show. I want to thank Netroots Radio and Real People's Media, Indigenous Resistance Radio, all of these other networks that carry this program. And I also want to thank all of you who share the show. However you do it, whether you share the Facebook live stream like my wife does, she posts it on a lot of other group pages across Facebook, whether you share the SoundCloud audio, whether you share the YouTube videos, whatever you do, I thank you all because, man, I tell you, we got to get the word out on this thing. We've just got to get the word out on this thing. And as I talk about what New York State is doing, let's be clear. This is a battle that happens across Turtle Island. Every state that has Native people in it trying to carve out livings, carve out an economy, those people are pitted in a battle against their states. And on the other side of that imaginary line, every province is trying to squeeze our territories. One of the battles we see playing out is the battle over medical marijuana. Even as states provinces, and Canada as a whole, even as they move towards legalization, they're still trying to squeeze native territories in ways that they won't squeeze anybody else. There's a prejudice that's involved here. It's racist. It is a racist attitude. And when I say racist, look, this isn't a stretch, folks. It is not a stretch to suggest that Canada and the United States, as well as the provinces and the member states, that they view Native people as inferior to them. That, by definition, is racism. That is racism by definition. And I read it all the time, and damn it, I got to read it again, because I know I look at the UN Declaration of the Rights of Indigenous Peoples as a flawed document. And it has to be flawed. Why do I say it has to be flawed? Because in order for this thing to have passed the UN General Assembly, they had to make sure that enough nations would agree with it. So what is the UN Declaration on the Rights of Indigenous Peoples? I'll tell you what it is. And again, I'll go to, I'll cite a specific article. There it is. Article 43. The rights recognized herein constitute the minimum standards for the survival, dignity, and well-being of Indigenous peoples of the world. So, to be clear, this is the minimum standard. And the minimum standard for survival, dignity, and well-being. No place on here does it say, is it the minimum standard for prosperity? No, it doesn't. Well, what's well-being? What does that mean? I mean, is that welfare? What does that mean, well-being? And dignity? Well, I got to tell you, Canada, United States, you are failing miserably from an international standard on that regard, because you can't even meet the minimum standard. Not only can your countries not do it, but your provinces and your states can't do it. New York State, you cannot meet the minimum standard established by the UN Declaration on the Rights of Indigenous Peoples. Okay, so you want to talk about racism. Well, this is the third affirmation of the UN Declaration on the Rights of Indigenous Peoples. It says, affirming that all doctrines, policies, and practices based on or advocating superiority of peoples or individuals on the basis of national origin, racial, religious, ethnic, or cultural differences are racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Look, if New York State, if you think that you're superior to us, and you do, I mean, I've looked at some of these cases, even in places like, Alabama and any place where there's been a case where jurisdiction becomes an issue. I've literally seen language in rulings that talked about the courts, the state courts, being the superior sovereign to whatever claim of sovereignty that a native peoples make. So they even use words like inferiority and superiority. And you know what? It's racist. Again, let me repeat. It is racist, scientifically false, legally invalid, morally condemnable, and socially unjust. Now, the problem is the international community can say this, but what do they do about it? And how do we give this stuff teeth? Well, first and foremost, we should be clear. Anytime we find ourselves in a battle with New York State or the federal government or a province or the Canadian federal government, one of the first things we should do is go through all of the articles of this thing. And there's, what is it all together? I think there's 46 articles. We should cite every violation of the UN Declaration on the Rights of Indigenous Peoples in our complaint, in our defense, in our assertions. Now, when New York State says, we don't care about that, that's okay. Let them say it. Let New York State or any state or province or the federal government or Canadian federal government say, look, we're not bound by the UN Declaration of the Rights of Indigenous People, because I'm glad to hear them say that. Why? Because we can't go in front of any kind of international tribunal until we can assert to them that we cannot get a fair trial in the United States or in Canada. And if they are prepared to allow their arrogance fly in the face of the rest of the world, so be it, then do it. It's kind of like Ruth Bader Ginsburg citing the doctrine of discovery in her ruling against the Oneidas. There's a part of me that says, damn, I'm glad she did it. Because everybody who claimed that she was some sort of liberal justice, this Jewish liberal justice on the Supreme Court, and then she cites the doctrine of Christian discovery to rule against the Oneidas. And the doctrine of Christian discovery is literally what this affirmation deals with. All doctrines, policies, practices, and practices based on or advocating superiority of peoples based on national origin, racial or religious. I mean, the foundation of federal Indian law, including any one of those jurisdictional cases, including Moe and Colville, rests on this notion that when white people discovered Native people, that they could claim that our sovereignty was diminished. Now, the problem with that is that there's contradictions there, one of which I talked about already, the Kannadiga Treaty. Because in 1794, the United States fully recognized that we had the right to title to our land. And they actually went farther than that and said, we will never claim your land unless you sell it to us. When the doctrine of Christian discovery becomes codified into law by the Supreme Court in 1823, what Justice John Marshall said was that our sovereignty was necessarily diminished upon discovery. Well, that's not what the United States said in 1794, 30 years earlier. And he said, we didn't possess title to land. We merely had the right of occupancy. Wait a second. You're saying that in 1823? But in 1794, the United States is saying, we recognize the land is yours, and we will never claim the same? But you know what? What do you think is holding water now? Kannadiga Treaty or the doctrine of Christian discovery? You bet your ass it's the doctrine of Christian discovery. That's how they cite every single ruling of jurisdiction over us. U.S. 232 and 233, Public Law 280. Every law that they cite, every one of the laws that the tax department cited against Eric White, every one of them is based on this notion that our sovereignty doesn't exist anymore. And why doesn't our sovereignty exist anymore? Because white people discovered us. Literally, that is what it says. And look, go to Ruth Bader Ginsburg's ruling in City of Oneida versus or City of Sherrill versus Oneida. Read her ruling, and in the footnotes, she'll explain exactly what the doctrine of discovery is. It basically says that the land became vested in the sovereign upon discovery. Doesn't say how that happened. Doesn't say, well, here's how it went from being native land, owned, titled, secured, sovereign land. She says the title just somehow became vested in white people. Why? Because they discovered us? That's the absurdity. That is the racist doctrine that the UN Declaration on the Rights of Indigenous People opposes. Now, again, having said that, we need to be more assertive in fighting back every single law that they try to cite against us. Not just the general stuff. And we can't leave an opening for New York State to say, well, we have this law. The first thing we have to say is, your laws don't apply. And here's why they don't apply. We can cite any number of articles from the UN Declaration on the Rights of Indigenous Peoples. We can cite all kinds of historical documentation where New York State, because in order for New York State to claim they have jurisdiction, there's a simple thing that they have to be able to document. When did the transfer of our sovereignty occur? When did New York State? No, not when did you claim to have jurisdiction, but when did we yield that jurisdiction to you? Because you know what? When US 232 and 233 passed, our people opposed it. We didn't agree with it. We still don't agree with it. So this notion that New York State or the federal government or any province or the Canadian federal government, when they claim to have this superiority over us, what is it based on? Is it based on military might? Is that what it is? Is it might makes right? No. There has to be a legal foundation. Remember this whole thing, rule of law, that you claim to be living under? Where's the law? Where is the transfer of sovereignty? When did it happen? It sure as hell didn't happen in 1794. And you know what? It didn't happen in 1823 either. And it didn't happen in 1924 when you tried to make us all U.S. citizens. You know what that is? That's a war crime. Denationalization is a war crime, recognized again by the international community. The idea of denationalizing somebody and then imposing your national character on people, that's a war crime. That's not me saying it. That's the international community saying it. And they've been saying it for almost a century. I think in 1913 is the first time that the international community began to address this issue of denationalization. And certainly after World War II, it specifically made it into the books, as well as the definition of genocide. And the definition of genocide includes assimilation, not by word, but by deed. The idea of trying to make a people no longer exist. And you know what? New York State, when you try to force us to only be able to operate any kind of economic base under your laws, that's assimilation, that's genocide. And it violates it violates not just the UN Declaration of the Rights of Indigenous Peoples, it violates the UN Declaration of Human Rights. And you know what? It violates your own Constitution. Because you cannot try to insist and then find somebody $1.3 million for laws that don't exist. And when I say don't exist, if you don't explicitly talk about native trade in your state laws, then you are already acknowledging that your laws don't include us. Because the bar is a little higher than what you're trying to set it. You think because you can impose some sort of law on Long Island or on Erie County that you can enforce that law on us when you won't mention us specifically. We are a distinct people. You cannot suggest that we are New York State residents or that our land is New York State. It simply isn't. And it doesn't matter how many times you say it, it still isn't true. It doesn't matter how many times you repeat a lie, it's still a lie. So New York State, you better figure out how you're going to back these claims up. And you know, all you people listening, and hopefully as this show gets shared, at some point, we have got to start getting pissed off and do something. Remember back in the day, we used to do things like block the throughway? Oh, now we're too scared to do that. I listen to people say, oh, you go out on that throughway and they're going to use the Patriot Act against it. You know what? Go ahead. I dare you to use the Patriot Act. I dare you to charge us with an act of terrorism because we're defending our sovereignty on our lands. You know, that throughway crosses Seneca land. It's not New York State land. It's an easement. That land that the throughway is on is Seneca land. That commerce that you conduct unimpeded, unfettered access across Seneca land, that's Seneca land. I mean, it's not yours. And the fact that you will try to stop us from conducting native-to-native commerce. Look, that wasn't a truckload of Marlboros. It wasn't something that is even available for sale in a New York State store. New York State wholesalers don't even carry that product. These are native products. These are native brands. These are the very native brands that in the Attea case, they cited was an exception to what New York State was trying to do. That it stood on markedly different ground. That's the language that the Supreme Court used. That our commerce, the commerce that we conduct with our own goods, with goods that we manufacture, that we add value to, that's different than you trying to impose every one of those New York State laws you tried to cite in this case against Eric White. Shame on you. I mean, it is pathetic. It is pathetic that you will play this game and not have the courage to flat out say, look, we don't recognize you as anything but New York State residents. I dare you to say it. I want you to say it. Don't just pretend that's the way you can conduct your business. Don't just pretend that's the way your laws work. Say it. That's what 2 state senators asked you to do. 2 state senators asked New York State to say, what is your position on native-to-native trade? You still haven't done it. I think that was in 2013. Maybe it was longer ago. I don't even remember how long ago it was. I mean, it is really pathetic that you as a governor and your agencies, the tax department, are so gutless you will not make a clear statement. You will not promulgate your policy or your authority. Why won't you? Because you know you don't have it. Instead, you're going to try to throw the weight of your prosecutors and your tax department and your judges, every one of them whose foundation is a foundation of racism, of superiority of peoples, racist, scientifically false, legally invalid, morally condemnable, and socially unjust. There is no way you can make these rules. There's no way you could throw Sean Snyder's case out, and still try to inflict $1.3 million worth of fines, plus the $160,000 worth of tobacco you stole from Eric White in ERW Enterprises. And look, again, I'm going to stand with water protectors. And I'll stand with any of you who are blocking a pipeline or a thruway or a railway. But you know what? We cannot sit back. This is not just a matter that should be played out in court. Because the court, years ago, when the United States was first off, 4 nations voted against the UN Declaration of the Rights of Indigenous People. This thing passed in 2007. 4 nations voted against it. The United States, Canada, New Zealand, and Australia. United States and Canada voted against the UN Declaration of the Rights of Indigenous People in 2007. But during the Obama administration, he began a series of consultations to reconsider the United States' position on the UN Declaration of the Rights of Indigenous Peoples. I went to those consultations. So did Ross John. The 2 of us. We went down to Washington, went to the State Department, listened to their spiel. All these agencies were there. In fact, a whole bunch of tribal leaders were there. They were more concerned about protecting sacred sites than really asserting the rights of indigenous peoples. Look, sacred sites are great. I just don't know which part of my mother is more sacred than the other. That's my view of things. But so in day 2 of those consultations, they opened it up. They had all of the agencies up on the stage, and they kept talking about clearing the slate and taking a fresh look at the UN Declaration of the Rights of Indigenous Peoples. But I was one of the people asking, well, why did you vote against it in the first place? Why do you have to revisit it today? Why did the United States vote against it in 2007? And they said, well, there was a concern about the UN Declaration of the Rights of Indigenous Peoples changing international law and interfering with the current remedy that the United States has for conflict. And they kept saying current remedy. And I said, wait a second, what is this current remedy? What is this remedy you're talking about? And they said, well, our court system. Wait a second. So you think your courts are the remedy for the conflict we have with you? I mean, how is that even remotely neutral? You have a whole body of law based on the doctrine of Christian discovery, still after all these years, and you're going to say that court is somehow the adjudicator of justice for conflicts you have with Native people? Well, there you go. There's the problem. The problem is you think that you can be the judge, the jury, and the hangman in every conflict you have with Native people. That's why you're afraid of the international community. You're afraid somebody's going to see you're not wearing any clothes. Look, folks, we have to step up. And I'm not saying this because we all have to defend Eric White. I will. But that's not what's at stake here. What New York State is saying is that they can interfere with any of our commerce. New York State refuses to acknowledge that our territories are not New York State. Just by virtue of them claiming that cigarettes sold in New York State, the whole basis of this has to do with where these things are going to be sold. So what they're saying is that the sales that we conduct are sales in New York State. When are we going to fight that? If not now, then when? And look, if you're not as animated about this as I am, then you're just not paying attention. And you can stand on the shore of every river you want saying you're going to protect water. But if we don't protect sovereignty, sovereignty is not our defense. It's what we defend. And we utilize that sovereignty we defend to defend our lands, our waters. Because I'll tell you, even that battle over water, the free, prior, and informed consent rule that is laced through this entire document addresses dumping fracking water in Coudersport. It addresses what happened at West Valley. But you know what? We still won't hold up this document. We make this thing meaningless. Look, it's not very powerful in the first place, but if we don't use it, it becomes irrelevant. We need to call out the United States, New York State, Canada, and the provinces for every time they violate and they stand in stark violation of the UN Declaration of the Rights of Indigenous People. That should be the starting place. We can get into their wrong application of their state laws and their federal laws, and we should do that. In fact, that's what the lawyers are for, right? The lawyers are to cite when New York State violates its own laws and when the federal government violates its own laws, or when New York State violates federal laws or whatever. But our sovereignty, that's up to us to defend. Look, I'm going to talk about this thing more. I only got a chance to look through this case, quickly. I'm going to talk about this more, and I'm blasting this thing. I am not letting this go, and I just hope that enough people hear what I'm talking about here and get as animated as I am. This is John Kane. This is Let's Talk Native. We'll see you on Friday.
Every kind of people got every kind